All right. Well, I'm super excited because we have Lisa Sutherland with us today. Lisa, welcome to Accessible.
Thank you. Thank you.
We are really excited to learn about protection and advocacy. But before we get into that, let's. I'm trying to think what's the best way, because let's just start with you and how you kind of came to be in the field of developmental disabilities and all of that.
Well, it was kind of a happy accident. I actually wanted to be a nurse growing up. And way back whenever I was an undergrad, there was the nursing shortage. And even though I passed the test to get into nursing school, I was put on a wait list. And so I had gone through 4 years and was still not starting. So it was just one of those things my dad tossed out. What about law school? And I always had an interest in public interest. And so, I thought, well, law school, I can see myself being a lawyer. And I was accepted at UMKC, took the LSAT, and I was a late application. So I was surprised that I got in. It was the only law school that I applied to, and I got in. And started from there.
I didn't realize that you were alumni here at UMKC.
Yeah,
so that's really cool.
It's been a long time. I started in 1997 and graduated from law school in 2000. But back then, they didn't have any focus on disability law. Yeah, I think I took one law and psychology class. Yeah.
Okay.
Well, how did you then, you got your law degree. How did you end up getting into disability law?
So I have one of my sister's son, my nephew, has severe autism. And so, of course, I grew up, witnessing the struggles of my sister with inclusion and education. And so that was always a part of my life. However, in those early days, like I said, I don't remember myself ever thinking disability law.
Right.
I don't know that was an area, that a lot of people sought to go into. It was always, towards which is personal injury or criminal. There was very little, if any, talk I remember in law school about disability law.
Yeah.
So even though there was an interest there, both personal and wanting to do, the public interest, there wasn't a lot of opportunity.
Right.
Certainly not a lot of training. So whenever I graduated from law school and passed the bar, I actually started with the Attorney General's office.
Here in KC?
I was an assistant attorney general, and I was working in the Jeff City office.
Okay.
Under... Oh, and I cannot remember his name. He's such a nice guy.
It'll come back to you, and then we'll insert it later.
But that was a long time ago. So, yeah, I started there in 2001, I believe. And so I started in the criminal division and moved over to the labor division, did some consumer. And even though I was learning a lot, I didn't find a lot of satisfaction in it.
Right.
And it was just a happy accident that whenever I was thinking of trying to find something where I could get more professional satisfaction, I saw an ad for Missouri Protection and Advocacy Services.
Okay. Well, that is pretty interesting. So now, what is Missouri Protection and Advocacy?
So, like most people, I had no idea. Their ad for an attorney just said that they are a nonprofit law firm with focus on disability law. And so I found that intriguing, wanted to find out more right away. Did a little bit of research and called and put an application online. And to my surprise, it's a very extensive organization. I didn't know that they were in all 50 states and territories. I didn't know that they'd been in Missouri since 1978, I believe.
Wow.
So, yeah, it was definitely a lot to take in. But I'm very happy there, still happy there. And still there. Yeah.
I was going to say, when you first said from nursing to law school, I thought those feel wildly different to me. But it seems like the connection is that you wanted to do something with and for people, like helping people. And so finding your way at PNA or protection advocacy, we say PNA for short in the DD network, but makes a lot of sense, sort of like in the vein of helping people.
Yeah, definitely. As I grew up, wanted to do something where, I felt like I was helping my, fellow man and contributing to society. So yeah, definitely a connection there, I think.
Mm-hmm. So like, what does a attorney for PNA do?
So it's pretty broad because we provide, disability services to individuals with disabilities. And so that covers everything.
Yeah.
So it's one of those jobs where you're constantly learning, but it's really hard to become an expert in any one area.
Mm-hmm.
For instance, I do work under the Americans with Disability Act, but I may only have one case every 1 to 2 years, and the law changes constantly. So by the time I get my next case, it's almost like I'm starting over.
Oh, right.
So, for the attorneys, most of the attorneys, including myself, what we love about the job is that we are constantly learning. It's always evolving and learning. We don't get bored too often because, we're not pigeonholed in any one area. We have a lot of input and discretion on the cases that we take. And like I said, if you do get bored, you can just ask to be, considered for a case in a certain area. You can request that whenever they're taking applications, they look for issues in a certain area. If there's something I or another attorney wants to explore. So lots of opportunity for growth. But it can seem a little bit overwhelming, like I said, because it is so broad.
Right. How many attorneys are there for PNA?
I'd say right now we're on the low end. There's been periods of time where I've been there where we've had over 10. And right now in the Kansas City area, we have myself and one other attorney. And she's taking active cases, but her caseload is low because she's running the voting access. And that takes up much of her time. So it's almost like 1.5 attorneys
right.
for the western side of the state. And then we have one attorney at the moment in Jeff City. We have one attorney in Springfield, and we have 4 attorneys in St. Louis.
Okay.
And do you split up cases then by region? You guys kind of work cases in certain areas of the state?
We do cover the whole state, and I wish that they did everything geographically, but and they try to do that when they can, so we're not traveling so much. But there have been times where I've had to take cases in St. Louis or Kirksville,
right.
Springfield. Yeah, so we do travel.
And I mean, I don't actually know if this is true, but you hear rumors of there being a backlog of cases that you all are working on, because there's a huge need for what you're doing.
Yeah, there is a huge need for sure. For some reason, we've always kind of been under the radar, and a lot of people don't know about us. But we have surges where we get a ton of cases, applications, and then we'll have a slow period, which I don't know why it fluctuates the way that it does. But we've recently had some grants where we've run low on funds. And so any backlog would be, we still continue to take those applications even if we don't have funds for the grant, and we will sit on them until the money comes in. And then we go back and try to reach out to all of those folks, who had applied. And sometimes it's as far back as 6 months, 9 months, or a year. A lot of times, they're no longer interested or the issue is resolved, but a lot of times they still need help. So usually the only time we have a backlog is in instances like that. We do try to open the cases as quickly as we can. Now, we do have a process called RUSH. So if someone calls and they have a hearing in a week or a hearing in a month, or there's some issue with restraint and seclusion, with someone's child, or the Safe Schools Act where they've been expelled, we consider those RUSH cases, and we will turn them around much quicker than we would an average application.
So then people don't have to pay for your services? Is that if
That's
you're waiting
correct.
for grants?
Well, at any time. In all the years that I've been there, I'm not familiar with anyone having to pay for any of our services. They don't pay for any of the filing fees or costs, and they do not pay attorney fees, so nothing. Now, there is one exception for Social Security, and actually I run the Social Security unit, which is a small group of attorneys that handle our Social Security cases. Now, for those cases, we do. If we win the case, we will accept the fee from Social Security. But otherwise, we don't collect anything.
And so is P&A almost fully, it sounds like, funded through federal grants or local grants, or what is
Yes. The majority of our funding definitely is through federal grants. We do have some income through the Social Security cases that we win, and donations, but I would say that's pretty small part of our funding. Now, with the federal grants, we don't have any discretion with how we spend that money, but with the money that we bring in from Social Security, and of course any donations, that's discretionary. We could do something we may not normally do with our grant money.
Right.
So who can reach out to you and to P&A and submit a case or a scenario, and do you serve all types of disability? Does your work cover all types?
Yes. So we have funding for developmental disabilities. We have funding for mental illness. We have funding for individual rights, which is kind of an umbrella. So that would encompass, elderly individuals who might have dementia later in life, who wouldn't qualify for mental illness or DD, or a younger worker who doesn't have a developmental disability but maybe has a TBI or back problems. So we have several grants, and like I said, the grants pretty much catch anyone and everyone, who has a disability, and almost every issue except criminal is something that we would assist with. Housing, eviction, I mentioned special education, Social Security, employment discrimination. We've taken cases up through the EEOC. So yeah, I mean, if you can think of it, and it has to do with disability and rights, we've probably done it, and some pretty unusual cases too, I would say. Yeah. I'm thinking of one I had where it was a student, I think she was in high school in southern Missouri, and she had a golden turkey, and it was her emotional support animal.
Oh, wow.
But the town she lived in had no fowl within city limits. And so they wanted her to get rid of her turkey. And, the city too, even though they had the ordinance where you couldn't have birds, so no chickens, I think that's what they were aiming for.
Right.
They said, how could you really have a relationship, with a turkey? And so I went, to visit her and her turkey, and the turkey was outside when we got there, but when the turkey saw her, you could tell the turkey knew this person.
Oh, wow.
Ran to her, and she snuggled with the turkey, but long story short, she got to keep her turkey.
Great.
So, we have some really funny, unusual,
That is unusual.
and lots of happy endings, I would say, with our cases.
Wow. I'm just thinking earlier, I was saying that there's a zoo evolving at my house, and now I'm thinking we need a turkey. We need a turkey friend.
I was not familiar with golden turkeys, but they're smaller. And much softer, I think, than what we think of a turkey.
Yeah.
Oh yeah, I was picturing the big.
Yeah, it was smaller. Yeah.
So it looks kind of like a chicken.
Very fluffy and soft. Yeah.
Man, I'm going to Google a picture of these golden turkeys later. For our listeners who don't know, TBI stands for traumatic brain injury. You had just mentioned it. Yes. No, we catch ourselves all the time doing the lingo and thinking we should probably explain that acronym. So,
I also hear that PNA has, in addition to attorneys, you have advocates. And what is the difference, or is there a difference?
There is. So the advocates, they're college educated, but not attorneys. But they do very similar work. We actually had 2 advocates who had become certified through Social Security and were able to do Social Security hearings before administrative law judges. Okay. So our advocates are very well trained and capable. And like the attorneys, they handle a whole array of issues. Our federal mandate is to try to resolve all issues at the lowest level possible. And that goes for the attorneys and the advocates. And so a lot of times they're our first level. You know, if someone received an eviction notice, but there's nothing yet filed in court, a lot of times they're very successful with, running interference, between the landlord and the tenant. And it's amazing, their numbers of resolution for these really sensitive cases. And our investigations, trying to think, our monitorings, that's all run by the advocates. Okay. Because our investigative unit is pretty active, and it's run by an advocate who specializes in mental illness, and she's been running it for many, many years, Jackie Tretchell.
Is there a sense of what's going on in the state or maybe across the nation based off the types of applications you're getting or the types of cases? Like, do you see trends in what you're getting a lot of requests for? And what does that tell you kind of about what's going on in our state?
We do. And so I think for the last couple of years, the majority of the cases for attorneys has focused on guardianship and special education. And so guardianship, I think that has become a focus in Missouri for a few reasons. One, there is a national trend where many states have already adopted like a uniform guardianship law just to make it more even-handed and fair across the states. Because it is so different from state to state. And even in Missouri, even though we just have the one statute, it differs from county to county. And so I think, individuals in Missouri, of course, we have a lot of strong advocates and self-advocates and agency advocates, and they're keeping track with what's going on nationally, and they see a lot of progression in guardianship and special education outside of Missouri. They want to see that happen in Missouri. And so they call us whenever they think, well, this, shouldn't be happening. I've read where it doesn't happen over here, so why is it happening in Missouri?
Can you talk, like, what is guardianship, just for any of our listeners who might not fully understand?
Sure. So whenever you're a parent, you have control over your child until they reach 18, whether they have a disability or not. You make all decisions for them financially, personally. And whenever that person turns 18, they're their own, they're an adult. They make all their decisions. So for individuals with disabilities, a lot of people worry about, them inheriting all the rights that everyone else inherits at 18, and what that may look like, and whether or not it could be harmful, or, how to manage that. And so there are ways to manage that without going to court, but most families, I think, are introduced to guardianship, which is through the courts at a very early stage in their child's life, through schools and other organizations. But guardianship is It's adjudicated in court. It is a court order where the person who's placed under guardianship is stripped of all of their rights. And so just like a child, another person, which could be a parent or a family member, or a non-related person, continues to make all of those decisions for them until it's removed by a court. So once you go to court and get a guardianship, it's not removed unless you go back to court and the court removes it. And guardianship has to do with the person. All decisions with the person, where they live, whether they can work, what they eat, whether they can have a phone, how much money they get a week to spend, and if it's not a parent or a family member, who they can visit, if they can even see their parents. And that does happen, unfortunately, if there's a lot of family strife. Sometimes a court or public administrator, which is a public guardian, may think it's in the individual's best interest not to have, those relationships. But there's also conservatorship. And a lot of times guardianship and conservatorship go hand in hand, and both are through the court. While guardianship is for the person, conservatorship is for the estate or the money that the person has or may come into.
So when you say you have a lot of cases around guardianship, are these individuals who are contesting guardianship over themselves or over a family member and saying we no longer want legal guardianship over this person? Is that the sort of case?
Yeah. So okay. we do not, as an organization, we will not help individuals get a guardianship. Now, if we look at a case and it appears to us that the person is in danger of getting a full guardianship, because you can have a full guardianship or a limited guardianship, and a limited guardianship could be everything short of a full guardianship, or it can be just one area. You can have a guardianship where the guardian only oversees, medication, for example. So if we look at an application and it appears to us that the person is in danger of getting a full guardianship, but we think we can help them get a limited, we would take those cases, to help them with the least application of guardianship instead of them risking full guardianship, but never full. But yes, the majority of the applications we get are usually from individuals who are under guardianship, who want to have, some or all of their rights restored. But we also get a lot of calls from friends and family members, wanting us to look into their, loved one's situation and seeing if we can help. And I don't think I mentioned this before, but anyone can fill out an application with us. It doesn't have to be, now if someone is calling on behalf of someone else, eventually we'll need to talk to that person, just make sure they want our help.
Right.
We're not showing up and taking over and doing things that they're not aware of and don't want. But anyone can request, our help for someone, for themselves or for someone else.
We've talked about guardianship a few times on this podcast, alternatives to guardianship and other things like that. But Lisa, if you wouldn't mind talking a bit about why for PNA is it important not to be a part of pursuing full guardianship? Is that like a values thing for PNA, and what does that mean?
Yeah, it is a values. As an agency, and I would say this holds true for everyone that works there, we believe that all individuals with disabilities should have the opportunity, to live life like anyone, have the same opportunities and choices. And Missouri has a protection model. Even with the changes to the law in 2018, we've still pretty much maintained that mentality that we have to protect individuals with disabilities. And so a lot of individuals with disabilities, they don't have the same opportunity to make mistakes or, to have any risk, associated with their lives, which, everyone, has, it's just a part of life. It comes with risk. And I don't think many people who are pro guardianship, think about that. that whenever you eliminate complete risk from someone's life, you basically put them in a bubble, where they're not experiencing anything. And there's no quality of life. So I think, it's definitely values, and we want to see opportunity. And we know that, guardianship is not evil. Guardians are not evil. Public administrators are not evil. It's just, I think in Missouri, a lot of people rush to that without exploring some other things. And I'm not saying that there could not be circumstances or situations where guardianship is not appropriate, especially a limited guardianship. I just think, like I said, we tend to rush to that too soon. Missouri has one of the highest, we're a state with one of the highest numbers of guardians and conservators. I don't know off the top of my head what the numbers are, but we're either number one or very close to number one in the nation.
Oh, wow.
Yeah, to the number of folks under guardianship.
That's surprises me a little bit. Well, so in addition to guardianship, are there other, Amelia had asked, what are the kind of big things that you're seeing right now in the state? Are there other things besides guardianship that are?
Yeah, so supported, other big things, special education, but supported decision making, which kind of ties into guardianship, so I can touch on special education later. But supported decision making is very similar to powers of attorneys, which have been around for a long, long time. And it's a document that's drafted, with the individual in mind, very, tailored to that individual, what their goals are, what their specific needs are. And it's almost like kind of like a legal contract where you can bring in your family and friends and community members or people you've worked with or want to work with, for your services, and everyone just meets and agrees. Yes, I can provide this service for you, and this is what it'll look like, and this is what it will cost, and you enter that agreement. So that's one part of this, supportive decision making. And then you can have backups, people from church or your family. So I've got this service provider and I have this backup service provider, but if there's an emergency and neither are here, then I've got my family, I've got my church members. And you can set up a schedule, you can set up your transportation, your banking, anything and everything, that the individual would need support can be, tailored within this document. And Missouri law in 2018 introduced supported decision-making into the statute. And so now for an original guardianship, a judge, which means a new guardianship after 2018, a probate judge, which probate is the area in the circuit court that hears the guardianship and conservatorship cases, a probate judge would have to consider someone's supportive decision-making document before they place them under guardianship. Doesn't mean they have to accept it and adopt it, but they are required under the law to consider it. But, whenever you look at the statutes as a whole, everyone, the probate court, the guardian, the public guardian, everyone is supposed to be mindful that the person is only supposed to be on guardianship as long as necessary, and they're always supposed to be in their least restrictive environment. And so I've heard a lot of individuals say, well, we can't really address someone under guardianship with a supported decision-making document because they're already under guardianship. It's not an original hearing. Well, if you think of it more broadly in terms of everyone's supposed to be thinking of their least restrictive, then you should be able to introduce a supported decision-making document at any time. It becomes appropriate for the judge's consideration, but that hasn't really taken off yet in Missouri.
Yeah.
So.
Yeah. And in special education, what's going on with special education?
So the big issue in Missouri is restraint and seclusion. There have been some positive changes. There have been some laws that have been passed, and then of course every school district has to have a written policy. on, how restraint and seclusion will be applied, within their school.
Can you talk about what restraint and inclusion entails?
So, restraint is where a person is either threatening themselves or others. And the individuals at the school who would be, implementing the restraint should be trained. Now, there's always emergency situations where one of those folks who are trained may not be close by. And if it is an emergency, you're going to do what needs to be done in that moment. But typically in the best case scenario, the staff will be able to recognize a student who's escalating and be able to call in the folks who have been trained in case it's necessary, to make it as safe as possible, because restraint can be a dangerous situation if you're not trained. And it's to hopefully de-escalate the immediate situation. And once the student is calm, then of course the restraint ends, and then they may be moved, to a secluded area. And so that's seclusion. But also, if you have a student who's being disruptive, but not necessarily an immediate threat to themselves or others, students will move them to a quiet room, someplace where they're alone. And a lot of times when they're alone, there's no teacher or anyone with them. They're truly alone. And they could be left there for extended periods of time until the school believes that it's time, for them to rejoin a class.
And so some of the data that you guys are able to track now is to kind of see like where this is happening in certain school districts, to then sort of point to what's the hope to gain from some of this new data.
So Missouri is pretty interesting. As when I mentioned earlier with guardianship, you see very different results depending on the county you're in. And that's the same with special education. Corporal punishment is still on the books and practiced by some schools in the rural communities in Missouri. And in some of those more rural communities, you may see the higher percentage of restraint and seclusion. I don't know, that the school districts necessarily lean into that. It's just, it's very expensive to train folks and to have behavioral therapists and appropriate support, come into, especially a rural school that doesn't have a huge tax base. To try to train the staff, but also to work with students to help them learn positive behaviors to replace some of the negative behaviors. It's a very complicated, dynamic issue.
But overall, is the data trending towards that kids with or students with disabilities are often being restraint and seclusion is often being used more with them than with the general population? Is that?
Yes. I'm sorry, I misunderstood your question, but
no, you're fine.
Yes, most definitely. Whenever we see, whenever we're looking at the data, the majority of the individuals who are restrained and secluded are unfortunately children with disabilities.
Yeah. I think though your first response though it's really important too is that that some of these other interventions are very costly, right? And so when we're looking at how to better equip educators and school districts and teachers, is that there has to be some investment in other interventions and other options, right? Because we know right now there's even a teacher shortage. And so we have understaffed schools. And when you have a student who is disrupting the classroom, or a teacher who doesn't know what to do, and the only other option is, put them in, they think, right, is to put them in a room by themselves. There's many levels, I think, to that issue, right?
Yeah,
so
there is.
Yeah.
I wish that I had the answer, but I don't.
Lisa, you don't want the answer to this?
It's very sad. I don't like those cases. It's very high stress for the family, and it's very emotional. That's your child. There's nothing more personal than your child. And whenever you believe the school district is mistreating them, the relationships between the parent and the school quickly devolve.
Yeah.
And, this is something I've seen in Missouri, that the use of child protection services is kind of being weaponized, I would say, a little bit in Missouri. That's something I never encountered, I would say, up until the last 5 years, maybe. It was rare for us to have special education students and families who have, issues with the local school, either implementing their individualized education plan or, even evaluating, for an IEP, which is the individual education plan, or a Section 504 plan. So you would have those disagreements, and sometimes they would be pretty tense, but the state was usually never involved. But over the last 5 years or so, I have seen, and I don't know if it's connected, but I have seen from my experience, the school, and because a lot of these calls are anonymous, not reported,
right.
but we have been able to get some data, through court orders where, we know who's making some of these calls. And it would be very scary to think that would become something that would catch on and potentially become the norm. Schools, if you have a student who's not potty trained, for instance, and if they come to school and they have a rash, I can see where a school may become concerned and would call, protection services. And those are the kinds of things, that we see more often. Whereas, before, in similar circumstances, just never had the state involved. And I've heard a lot of parents also express not only, Child Protective Service, DSS is involved in their case, but they worry about them becoming involved in their case. They're worried about pushing too hard, for certain things that they think that their, children, are entitled to, because they worry about, what may happen with some sort of retaliation.
And so you use the term weaponized, and so do you think that's actually happening, or it's just a fear at this point?
I don't know that I would say that it's happening, because I don't know that the numbers are broad enough to support it.
Right.
But it is something that I've never experienced, and over the course of 15 years, but have begun to see and experience over the last 5 years. Yeah.
Okay. Wow.
Interesting.
Yeah.
It's big stuff.
Yeah, it is. Well, so when you think about maybe it's these issues, but when you think about the next, say, 2 to 5 years, what do you think are the big issues that we'll be facing in Missouri?
I think guardianship will continue to be up there. There's so many smaller issues that go with guardianship. It's really its own specialized area itself, but most definitely guardianship. Housing is huge. There's a lot of individuals in Missouri that are living very secluded lives because there's just no housing for them. Most people think, if you are lucky enough to get a waiver and you have been slotted for, community living, then, you are in the community and you're not isolated. But consider, someone with a disability who does have a waiver, but their guardian has placed them in a very rural setting, and their only roommate is nonverbal. So that person may actually have a waiver and they're in the community, but they could be more isolated than someone who's in, a nursing home. So it's very nuanced, and even when you think you have the answer, you found a solution, you see that it doesn't always work for everyone. But yeah, I think Olmsted, community living, and special education, I think those will continue to be hot topics for the next few years.
Yeah. Okay.
I do have a final question.
Yeah, go
because
for
you
it.
had mentioned a voting access project. And so I don't know actually when this will be edited and out, but we are in an election year. And so if individuals want to know about their voting rights and how to get registered or anything like that, is that something they can go to your website and find information about? Or what is your voting access kind of project?
So there's a protection and advocacy voting access, PAVA. So we actually have a grant specifically for that. And even on non-election, like when I'm going to say non-election, I'm talking about like the big years for presidential, we still do voting access work.
Right.
And yes, any questions about voting in Missouri, concerns about voting, they can get in contact with us. It's the same website for the applications and for any of the grants, including PAVA. It's moadvocacy.org. And they can either leave a question or they can fill out a little questionnaire for an application to be submitted online, and someone will be in touch with them. It's pretty fast and painless process for the applications.
All right.
That's great. You guys are doing that.
Yeah. Well, Lisa, thank you so much
You're
for
welcome.
spending this time with us.
Pleasure.
Yeah, we really
was.
appreciate it.
All right, thank you.